cases you want us to start with today?
Everybody, this is Attorney Ilya D. Philippus, Chris Cody. Chris works for the department. Ilya is a private counsel, and they were actually the trial attorneys on the Linus case, the first case you had to read today. So most, if not all of the class will be taken up on a discussion. And they're going to talk about it, but feel free to, do you want them to interrupt as you're going along, or?
Yes.
Okay.
Have they read the case? Just so I know.
Yes, right?
You read the case?
Everybody read Linus? Good. Okay.
So I represented the mother in this particular case for a number of years before it finally went to trial. It was a care protection that opened up back in, well, excuse me if I don't remember the dates. It goes back some time when only the first child was.
Probably about 2005 or so.
Yeah, that sounds about right.
Involved.
That sounds about right. And the issues were really homelessness, which is not grounds for the Department of Children and Families to remove a child from a home or lack thereof.
Yeah, I'm just going to also interrupt your question. So
Sure.
They had the two boys, and we're calling them Linus and Malcolm.
Right.
Do you remember how old they were initially?
So
They were
at the
really
time,
young.
they were young. Well, again, there was only one initially.
Oh,
There was
okay.
only one initially, and they were homeless.
I can look on with her if you want.
No, they don't need it. They certainly.
No, that's okay, thank you. So it was one child at first, and then the second one was born later on. But the issues around this particular family were substance abuse and homelessness. And we eventually got the Karen, so you have to excuse me if my memory isn't 100% here, but I want to say initially before the second case opened, the first one was dismissed eventually because of that. Homelessness is not a grounds to remove a child from a home, and the substance abuse issues were in fact dealt with. The mother and the father had a very long-term relationship, and they still, because I keep in touch with them, are still together today. They have 3 children now, 3, and all 3 children are theirs together. So they have always been a couple that has been united and together, and both having substance issues that were addressed, and the homelessness again.
Can I ask what the substance issues were?
Heroin.
Yeah.
Heroin.
Both, right?
Correct. Then the second one came along, the second child, and again, the issue of homelessness and substance abuse. Then there was a third child.
So where were they?
Sorry?
Homelessness.
Where were they?
Living out of their car?
Where were they? There
Yeah.
was no car. They were living in a park. And they were, because I know.
Mother was in the park, and father was with his parents.
Yes. Father had a very rooted family in the community. I suspect that he was sort of with his family because they were a strong family from Portugal, and I don't believe for a second they accepted who he was with. They were always together, though. They were always together. But that's correct, Chris. And so she was living with the kids in a park, and I know because I saw. And I used to see them together pushing the kids around in a grocery carriage, and I remember kids being really bitten up badly.
I was just going to say the case discusses the father not cooperating with the service plans. You want to talk a little about that?
I didn't represent the father, but he for sure was reluctant. Is that a good word, Chris? I don't even know if reluctance is the right word. He was extremely shy, painfully shy, and I think that prevented him from being able to communicate with anyone but the mother of the children, his long-term relationship. When I would go there to visit my client, the mother, he was always there, and he communicated with me fine. But I was sort of disarming and non-threatening. I looked at it like I was there to help both of them, because I knew they were together, and I knew they would remain together. Of course, I didn't advise him legally, that would be a conflict, and that would be unethical for me. But I saw that this was a person that if you handled in a certain way, he would respond. And the department, you know, they're prosecutors, so it's your burden, you have a goal, you have an agenda, as do we, but the manner in which they would communicate would be far different from the manner in which I would communicate. It's sort of more aggressive. Look, this is what you have to do, A, B, C things, and if you don't, this is what's gonna happen, and that can be very threatening, and so I think it caused him to shut down quite a bit.
What was the main holding in Linus? Does anybody know? What was the, anybody use Linus would be the strongest reason to use Linus?
Did the judge terminate their parental rights?
The trial court did terminate parental rights.
So what is the
And
answer?
then it was appealed. Which court did it go to for the appeal?
Their reading was just the appeals court review of juvenile court judge's decision findings.
What
So
do you
can
think-
tell them the future history of the case as well afterwards.
So what happened? What did the appeals court hold?
The department did not meet its burden of proving current parental unfitness and clear and convincing evidence.
Right.
So I think the issue they were talking about was, it's not necessarily how you were in the past. If you were unfit back then, is irrelevant if you're fit now.
That's right. And does anybody happen to remember one of the main reasons why the appeals court held the department didn't meet its burden? Yes.
The state did not meet its burden.
Right.
Why?
And the question is, can you remember why the appeals court held?
I'm
Yeah.
trying to refresh my memory.
One of the reasons was there was no expert testimony showing that the children would be affected from leaving their pre-adoptive parents. There was no bonding that was, you know, long-term that would affect the children.
And what else did the appeals court say about the bond and the department's conduct regarding the bond?
It kind of came down to the department quite hard.
Yes. What is it, according to the appeals court, what did the department do that wasn't?
Exacerbated the problem by terminating visitation without court approval.
And I will tell you, obviously, the proceedings are closed proceedings, and Ilya and I aren't telling you the names of people or anything like that, but that was an issue which Ilya continued to bring up throughout the trial, right at the very beginning. I was not the original DCF attorney, I came in the middle of it, and as your case indicates, the department had terminated business. The appeals court held that the department had terminated business without legal court. And essentially, the appeals court said to the government, you can't break a bond and then hold it against the family with a piece of evidence, which is essentially what the appeals court, I think, held. Was the DCF improperly terminated business. And then I argue that parents weren't visiting, essentially. And that's what happens when you represent an organization. And if you represent a government entity or a corporation, you don't get to pick your cases. You're assigned a case, and you have to do the best you can with it.
Do any of you remember if and when the department does suspend visitation, what should, and I know Ilya did it, you talk about it, what should the parent's attorney do? If the department's, if her client calls her up and says, the department isn't letting me see my kid anymore, what should she do legally?
I want a court order saying that.
And what does that mean? What does she have to go and file in court? Patricia?
A motion to appeal?
No, it is a motion. And it's a couple of cases that we read when the department doesn't follow its regulations. Do you remember?
Review? It has something with review.
Motion to roll the dice.
Ah, it's a self-blind watch. I'm shaking my
Do
wife.
you remember the Isaac and Jeremy cases? So what kind of a motion is it?
So when the government has
No, you'll
this sort
refresh
of,
your memory, all right?
well, the government has discretion,
Mhm.
okay? And when that discretion is abused, so in this case, the department unilaterally terminated visitation, which parents had a legal right to have, and without, well, I would argue without cause, just unilaterally terminated that visitation without, like you brought up, leave of the court, or as Chris brought up, you need to get permission from the court to do that.
And the interesting thing in this
The department
case,
did not.
that in fairness to the trial judge, what she sort of did, if I remember correctly,
Well,
was she recognized that Ilya had filed the motion and said, I'm going to hear the motion as we try the case.
right,
Which, now, think about this. Here's a question. Ilya filed the motion, holding that arguing that we had abused our discretion. Who has the burden of proof on that?
no, the
Not
plaintiff,
really, the moving party.
Moving party, which was Ilya. Who has the burden of proof at the trial? Commonwealth. So we have a motion in which Ilya has the burden of proof. We have a trial in which I have the burden of proof. And it's all being sort of simultaneously heard. The judge was trying to do the best she could with the chaos in the moment. And as a result,
well,
it really never got done.
well, if you saw the case, you read the case, obviously, because you said the appeals court came down on the department. Did you also notice how hard the appeals court came down on the trial judge?
Yeah.
I think worse than the department,
Yeah.
because in my mind, the department or any prosecutor or any defense counsel, they have their agenda, but it's up for the judge to referee that.
Yeah,
And
you-
to make sure that the prosecutor's acting properly and within the meaning of the law, and that the defense is.
Yeah, you're.
And the judge didn't do that.
She came down hard, a lot of the language is on the department, then you're right. The few things she said about the judge was basically, and shame on you for not recognizing.
That's correct,
Yeah, I just-
that's correct, and not refereeing that properly and stopping it
Yeah.
and fixing it and getting everyone back in line. And I would say that, I'm sorry to interrupt you, I would say that the judge took a harder hit than the department.
What do you say?
So I think what the judge was answering to Professor Phelps' question, is it the review and redetermination?
No.
That
No,
was
it's
correct?
abuse of discretion.
Discretion motions under the
Okay.
Isaac and Jeremy cases that
Okay.
you guys have read before. And if I remember, Ilya had filed her motion, and the motion sat for a very long time.
I repeatedly
So
brought it
think
up.
about that. We know that up until parental rights are terminated, and even sometimes after that, parents have a right to visitation. So for a long period of time, that issue is not being decided by the judge.
It wasn't
there was
decided till the
certainly
end.
Some error in at least coming to a decision, and you know that, what's the standard for suspending visitation by the court? No, suspending visitation. What has to be shown in order to suspend visitation? That was the custody of minor case, one of the custody of minor cases that we read. Say it loud, Lester.
The health and welfare.
Yeah, harm to the child, right?
Harmful to the children or the
So
public welfare.
she should have held a separate hearing to consider that issue well before the trial. So that was only one of the problems with this case from what I remember.
But what it did do was create, as Judge Traynor said in another case that I was involved in some years ago, where that case was actually won at trial, not on appeal. But I remember one particular judge saying, I'm not going to allow the passage of time to create a best interest case for the department, when the department sort of similarly did something of that nature. He stopped it. He stopped it. At this particular trial, at every court date that we had, every trial date that we had, and there were several, how long did this case go on for? I kept bringing it up to preserve that issue on appeal. Okay, and I knew she made it clear she wasn't acting on it, and I knew that I was probably agitating her by bringing it up again and again and again, but she knew I had to in order to preserve it, and I tried as diplomatically as I could to bring it up again and again, but it was never acted on till the very end. So it was appealed.
So getting back to the standards at the time of trial of the current fitness in the best interest, because they're not doing the termination.
On
What-
2 of them, and the
Yeah.
other child was,
I'm glad you brought that up.
Yeah.
So, you know, what factors did the court go into?
the past, the past. Years before, the
What-
behaviors from years before. They couldn't look at anything current, and that is the standard current fitness. There was nothing. There was nothing. You know, you only go to trial on a case that's triable. If you have a case, you go to trial. If you don't, you don't. You work it out, you figure it out. This was a triable case because the government didn't have a case at that time.
But we thought we did.
At that time.
We still think we had a case.
Tell us about it, Chris.
Well, our case, it is admissible in a termination of parental rights trial. It's admissible to rely on history.
That's right. Termination.
You know the different levels of hearings and trials that occur in child protection cases. Termination of parental rights trial, the case law does allow the admission of history. We're able to argue that based on history, that the history does go to current fitness. Now, do you think that's a strong argument?
No, not sole history, not relying solely on history.
Because they can change. Yeah, such.
I think it's how you present it.
I mean, there is no accurate answer to my question, because
Right.
it depends on the facts. What if the history is people are consistently killing their children, and now we have 2 new kids? History would matter a lot in that case.
Right.
So it's a very fact-specific thing, and that's less of an admissibility question as it is a weight question. Those of you who've taken evidence, you understand the difference between admissibility and weight. Who can give us an example? What's the difference? What does admissibility mean?
Whether or not it comes into the court.
Whether or not it comes in, what does weight mean?
How much it's going to be relied upon by the judge.
Right, or the jury, whether the judge is a finding of fact. In other words, weight means, does it matter to anybody? So history is admissible. How strong is the weight of the history? And in this case, it was enough to win at the trial court level. Did the appeals court hold that there was not enough evidence?
No, not enough weight.
What did the appeals court hold about that? Yes.
There was too
Too much
much.
time had elapsed to give the history the weight that you wanted to hold.
So what did the trial court, what did the appeals court hold about whether the judge correctly found that DCF met its burden? Did DCF meet its burden of proof according to the appeals court?
No, no.
Do you know why DCF didn't meet its burden of proof?
Well, they were no longer homeless during the appeal.
And what else?
What else did you?
So you can do a list like that.
What about the substance issue?
Yeah, they were clean for 2 years.
Stan, what did you say?
But she was clean.
She,
For a while.
what about him? What about the condition, and condition might be the wrong word, of the young children? Because remember, we talked about fitness in and of itself, you just can't consider that by itself. It's your fitness to parent this particular child. So what about the young children and the parents' ability to parent the 2 that had varying needs, let's put it that way? No, they're not usually like this. I don't know whether you 2 are different.
Okay, what's your question again?
I don't know. The 2 little kids, what was, other than, I mean, were they developmentally, appropriate? Did they have issues?
One of them
The
had
little
Down
girl
syndrome.
was handicapped, wasn't she?
One of the little boys was needy, but they brought up that they'd formed a bond with their foster parents, or they call them pre-adopted parents.
One of them has Down syndrome.
Well, which one?
The little girl.
Well,
That's the one the department was not looking to
Right.
terminate rights on.
But, so
I'm
I
talking about-
thought they had concern whether they could provide enough, care for the boys while
Because
she
why,
was so
Patricia?
because she was so needy, but then they realized that they were in school, so that gave mom time to do work with her, and then she became involved in the program.
That's something the department brought up, was that she's barely fit to parent the girl child with special needs.
Mhm.
I believe they call him Malcolm, was also needy, and the department was like, if you can barely take care of the one needy child, we don't think you're gonna be able to handle the burden of two other boys, one of which is needy.
And what did the appeals court say about that?
Insufficient evidence to prove that at that point in time.
Because there's developmental programs for her, and then the other two boys would be in school.
So I had to argue that the court should infer from the facts, which is always a very good place to be, that the court should infer from those facts that mother and father were unfit to care for those other two children. And obviously, we can't tell you what the testimony was because they're closed proceedings, but boys did testify. And well, I suppose you're all interested in this area of the law, you wouldn't be in this class. Having children testify is a very different experience. You may have read some case law which says the court has broad discretion on how to set up the courtroom, for example.
We have been talking about that in the context of child sexual abuse cases.
Excellent. Well, in this case, it was actually a table, much like this one, and the judge sat at the table, and each child individually testified, he sat at the table. You know, the rules of evidence still apply, but you can imagine how different the tone of the work is. And the skill that, as an attorney, you have to develop is, how do you think you have to present yourself in those moments? Think about it.
Very likable.
Yeah.
Delicate.
You've got delicate is a good word.
Delicate.
For
Children at the time?
under 10?
Yeah, 10 and maybe 6.
That's right. So you've got this, as a practitioner, you've got this, I'm speaking in general when you have kids testify. On the one hand, as Ilya has correctly pointed out, you've got to preserve the record, which means you've got to object when it's necessary. But you also don't want to spook the witnesses, right? You don't want to terrify them. It's very important because they're just little kids. And you also don't want to irritate the judge by being heavy-handed on these poor children. So you have all of these other issues now in your head. It's a good example where litigation is an art, not a science. At the same time, you need to extract the testimony that you hope you're going to get, while balancing all of those other issues. So it's extremely hard to bring children in as witnesses. And the other problem is you never know how the children are going to testify.
That's right.
Because obviously you would never coach a witness. And in my case, I didn't represent the children, so I couldn't really even sit down with them and prepare them. So it's a very dangerous game to bring children in. And as you can tell by the ultimate decision the appeals court made, it was necessary from an evidentiary standpoint for us to bring those children in, because at that point our evidence was increasingly weak. And you know, our position continues to be that the children should have stayed in DCF custody, should have been adopted. You know, we don't agree with the appeals court, we respect it, of course, and follow the orders. But we felt that those boys needed to move on. And when you have to deal with a child testifying, whether you're in the criminal forum or in the civil forum, as we all are here, it's one of the hardest decisions you make. Because then you've also got the humanity aspect of it, where you think, what am I doing to these kids? Is this good for the children? Is this not? And in general, I've had many cases where a social worker has said to me, or management has said to me, even if we lose, we don't want to put the kids through this. Because the greater evil is the trauma that children may sustain by testifying. It's an endless, balancing of the needs. So we'll sometimes make the decision we're not going to have the kids testify, and we may lose as a result, but we're not going to burn the village to save it. And there's no way we can teach you these things. except to alert you to these facts, so that when you start practicing, you're aware of it too. Because each case is so unique on the facts. Some kids, it's the best thing they can do is testify. It's healthy for them, they're articulate, great witnesses. Other kids, you may have a therapist say, don't do it. You're never going to recover if you do this. Okay? And in the end, what matters most is the children, not advancing the government's position. Now, here's the interesting thing to think about. If you represent a parent, and the parent says, I want these kids back and I want them to testify, and you as the attorney think this is going to be horrific for the kids, what would you do?
You don't have an option, do you?
And this may be a trick question, so think carefully. Your client says, I want these kids to testify. Call me. Yes.
The client determines the scope of representation.
What is your answer to my question? What would you do?
You're on the right track.
What do you do? Your client says, you represent mother, and mother says, I want these kids to testify. And you think, based on your reading of the record, you think, I'm a therapist, got a therapist saying this is horrible for the kids. I know the department or the DAs are calling these kids because they've been advised. You're going to really ruin these kids. But your client is saying, you put them on the stand and they're going to say the right things. What do you do? What are you going to do?
Well, I certainly might have a conference with my client and the therapist and social worker.
Therapist says bad idea, worker says bad idea. Your client says, you put them on the stand, I know what they're going to say. Here's what they're going to say. What do you do? You don't know. What are you going to do?
I would argue that putting the kids on the stand would have a, severe, traumatic experience for them.
And the mother says, that's fine. It's better that they be with me, though. They will get over it. They have a therapist. It'll be 20 minutes of difficulty, but they'll come back to me.
You can still admit that evidence, but you wouldn't have to get them to testify in court. You can still,
How are you going to get their words into evidence if they don't testify?
If they're under 10, can it come in?
Yeah.
Only if it's child sexual abuse, remember, that's 233-81-83 in this case that you guys are talking about. No, that doesn't apply to Chris's question.
So what would you do? Would you say, fine, put the kids on the stand?
I couldn't.
You couldn't. Okay.
For the kids' sake.
You don't represent the kids. They have their own agenda. You have a client.
Yeah.
So are you going to act in the best interest of somebody else's client? And anybody can jump in. What would people do?
Well,
Yes.
I would suggest to her that it would make her look even more, in a negative light, because they're telling her these kids are not able to stand trial, and she's insisting. So for her benefit, if the kids are not able to stand trial, maybe she should understand that, and that would, give her a little bit of favor, if anything. But I would,
Now, I'm your client. I'm saying, look, I want to win. I want my kids back. My kids are going to say they want to come back with me. They're going to say that everything was a lie. I want to go back home with mom and dad. Are you going to put those kids on the stand?
no.
You're not going to do it. Why?
I mean, I think the therapists, they know what they're doing, and for them to say that this will have a lasting effect on the children, whether or not they go back to their parents, that effect will still be there.
So what if you lose them? You put the kids on and you lost. So you spared somebody else's client the trauma.
And she's going to appeal on ineffective assistance of counsel.
I know.
Sounds like you either got to do it or withdraw.
Yeah. I would withdraw.
Who? Okay, yes.
I would definitely put them on the stand. I mean, the mother, I would think, depending on the mother, has some connection with those kids that somebody else might not. And maybe it is an error of the court and the system that they should be with her, and that it was just...
So you're saying, I don't care what it does to these kids,
No, I'm not saying that. If the mother thought they should be, this is their freedom. This is their right to be with mom. I just think I would weigh all the totality of the circumstances, but I think I'd err on the side of caution. If you let those kids go, I've seen too many kids that get to 18 and they will never be right because they were pulled from home for whatever reason, whether it was given up for adoption involuntarily or done deliberately. in a court situation, so I don't know. I think I'd rather err on
What
the
do you
side of
say?
caution.
I would try to find an alternative, maybe even, I don't know, strong, I don't know, I would say a better alternative than that. Maybe could possibly the therapist even testify? Because I know that there are times where children can give information to their therapists or their social workers on how they feel.
So it's not a sex-based case, so we want to get the words of the children.
With children. Yeah, then I would just withdraw.
You withdraw.
But it leaves the problem for another attorney to deal
I
with,
know,
Cassandra.
but then it's like.
How does that help you? How does
You know,
withdrawing help your
I guess
client?
maybe I can.
It doesn't.
It doesn't, that's
You've
what-
now withdrawn, and how does that help your client?
Okay, so maybe I wouldn't draw, because then that's just giving up. So I wouldn't give up, but then would seriously have a conversation with my client and
That's
say,
if the court
listen.
allows you to withdraw.
Right,
So,
that's enough.
Yes.
so then I would have to,
Go
but I would really have to get the point across to my client, like, listen, here's what we're dealing with, and really try to find another alternative. Maybe try to reason with her so that she could let go, he or she could let go of, well, I need to have my kid on the stand. And if not, I don't know. Maybe it's not a good question for me because I was a social worker, so I don't know. I was a social worker, so I don't know.
Maybe have the judge interview the children in his private chambers and
Does the case law allow that?
is it only sexual abuse cases?
I'm not gonna answer that, you answer it.
If you know, you may not know the answer to that. It's called
It's
an
the
in-camera.
hearing. You guys had at least a couple of cases on that.
Can the court do that?
Yes.
How, so what do you think we do then? You ask for in-camera? Does anybody know what is an in-camera?
Judge's chambers.
Who would be there?
The
It
judge.
would be the, I'm sorry,
Oh,
Ash.
sure.
Would be the attorneys for both, the advocates for both sides.
Does everybody agree with that?
No.
It's just,
No.
it's
Oh,
just the
no.
judge
It's
and
just the judge.
and the child.
And the child.
And then the.
It's recorded.
Other people are watching it on TV. I don't remember how they set up the objection part. The case is fuzzy, but it was just, I thought it was just the judge, the child, and there might have been a reporter, yeah, the child, and then representative, and then, but the opposing.
You're talking about the Bergstrom case which dealt with the screening of criminal, but Chris is just asking what, generally speaking, what's an in-camera hearing in custody case?
I thought they were only sexual.
Frequently, the attorneys propose questions. One way it's done is everybody proposes questions, and ultimately, in a lobby conference with the judge, people agree on what questions the children are going to be asked. Obviously, this is an area that's ripe with opportunities for appeal. But this goes to a larger question, which is, as the attorney, who controls the litigation? Client. Who controls litigation strategy? Who controls the practice of law? Is it the client or the attorney?
The lawyer.
So the lawyer makes a decision on witnesses, or does the client?
It's the lawyer's job to strategize, to call witnesses. It's not the client that's going to be doing that.
Does the client, if the client says, these are the people I want to testify, do you have to call?
No, you don't.
You only have to allow your own person, your own client to testify unless you think she's gonna perjure herself or something. She's the only one, like, he or she, that, you can't deny them the right to take the stand. Again, assuming they're not gonna perjure themselves, but.
What do people think? Who makes the decision?
I think the client, but if the lawyer sees that there's gonna be a problem, then he can advise the client that this witness is gonna be a potential problem.
Two different views. One is the client makes the call, the other is the lawyer makes the call.
I'm a lawyer. I gotta do my job to win your case. If you're gonna play lawyer, then I'm gonna have to withdraw. I mean, that's how I would position it to my client. Why are you hiring me if you're not gonna take my legal advice? If you're not gonna have me run the case the way it should? In the best interest of you, of course.
So we split 50-50.
It's like
be argued, right? That's why we're in business.
You know, when you take your professional responsibilities, you know that you can't report to a non-lawyer, right? If you're an attorney, you can't have a non-lawyer as your boss. So I would suggest there's a strong argument that you make the final decision on what evidence you're going to offer.
Could you tell the client, based on my experience, this is not a wise decision? My experience tells me we should preclude the children's testimony.
Well, actually, you modified my original question, which was, you want to bring the kids in.
Oh, you want to bring them in?
Yeah, actually, I drifted from my own question.
Oh, you did?
Yeah, I mean, the question was, would you have the children testify even if it's injurious to the children?
Right,
We got into a very interesting side conversation, which was good to have. I'm going to get back to the original question, which was, you know it's going to be injurious to these kids, and you also know it's going to advance your position. Would you call the kids?
In camera here.
Okay, if that's denied, which I can think of several judges that I've unsuccessfully tried to do that with.
Yeah.
So I'll tell you, every time I try to call the child witness, that's my first position. And I'm very rarely successful, even though the case law allows it. But if you know, as you know, the case law gives the trial court discretion.
Wouldn't you think that they would want something like that? I mean, a judge wants to know what's really going on, and if they have that private experience with the child, they can understand the true facts.
The problem is, frequently it's not the case. So the question that you have to think about it, what would you do? You will advance your client's position, and you know it's going to hurt the kid. I'm not just saying anything, there's nothing unethical I'm suggesting you do. You're going to properly call the children, but a therapist is saying, boy, if you put these kids on the stand, I'm going to have them medicated by midnight tonight. Yes.
Okay, so is there any way we could prep the children, maybe?
You don't represent
not,
them?
no, I mean, no, not prep them for trial, but I'm talking about the therapist, saying this is what you're gonna go through, so, you know, in a sense of not therapy.
See, I'm not letting you out there easily, because the therapist has already said to you, this is bad for these kids. I can't think of a safe way to smoke a cigarette and pump gasoline, so I can't give you any advice. What you're doing is bad.
So, is there a safety net that we could, is there something that we could build for after trial
Here's
that
what will
maybe
happen.
that would,
I will have these kids institutionalized.
after trial?
Sure, because what you're gonna do to these kids is gonna force them to relive the trauma. And they're gonna be torn between seeing their mother sitting in the room. They're probably gonna testify that they want to go home because almost every victim wants to go home. Right? Very few kids, you can do almost anything to control their parent, and they often want to go home, because that's what they know, that's their home, these are the people who love them. I mean, in my experience, I've found almost no parent protection parents who don't truly love their children. They have a lot of difficulty, but they love their kids mostly know that. So here's the problem, you still need an answer, are you going to put these kids in the stand to help your case? Yes.
I think if the short-term harm is going to be outweighed by the long-term good, then yeah, you do it.
Do you have any duty to these children?
Just as a human being.
Yes.
They're not your client.
Not as an
I
attorney.
know.
Not your client. To whom do you owe a duty?
Just your client.
And of course, what else? What institution?
The court.
The court. You owe a duty to an officer of the court. You owe a duty to the court. You owe a duty to your client. You owe any duty to somebody else's client.
Should I spend
You know,
one?
they're agonizing over this right now.
Think about it.
As always, Ilya has the answer.
I don't know if I have the answer, I mean, I know what I would do.
What would you do?
What would you do?
I'll tell you, it's like Chris was saying, you have a duty to the client, right? And then you have a duty as a human being to respect, like you said, as a human being to respect the professionals and, you know, what the therapeutic recommendations are and what have you. But what I would do is I wouldn't file a motion to withdraw, because the judge has to allow that. That's not automatic. You don't just
Right.
file a motion to withdraw and say, Judge, I'm looking to withdraw, especially at the 11th hour, we're in the middle of a trial now, right? Okay? The judge is gonna wanna know why. Now, I have filed motions to withdraw, not many, but I have. And boilerplate reason I'll give is there's been a breakdown in communication. You know, but it wouldn't be at that point in time. We would never get to that point where we're in the middle of a trial or about to begin that I would ask to be let out. I wouldn't do that. So, respecting that this is what she wants, I know it's not the right thing, but it's what she wants. To cover myself too, right? Gotta cover myself too, that's another thing you need to think about. CYA, never forget that, that's real important.
And you're also more likely to win.
Real important.
Under this
Cover
example,
yourself.
you're more likely to win if you call these kids.
You're gonna ask the court permission. And let the judge make the decision. Now it's off your back.
Yeah.
You put it on the judge to decide. So, I did what you wanted, and now it's in her or his hands to make the decision. I'm not gonna tell the judge this is what I'm gonna do, I'm gonna ask, respectfully. And the judge will make the decision, am I right about that? I've seen that happen. Okay, we'll do an in-camera interview you know, based on what age the child is, and like you said, would it in fact shatter them, or maybe it wouldn't. But I'd ask the judge and let the judge make the decision, let the judge guide me and direct me. Give the verdict to the court.
Yeah.
So, just clicked on me, but one of the missing links I didn't think we thought about, in your hypo, the kids must have their own attorneys.
Thank you, okay, I was waiting
So,
for that.
I didn't think about that. If that's the case, then yeah, you fight tooth and nail for what your client wants, fight to put them on the stand, because the kids are gonna have
And
their own
Jeremiah,
attorney,
if
shoving
you
the
have, if
therapist in
there's
front
a
of the judge.
competent child's counsel, and if in fact therapists, you
Yeah.
know, they are gonna be traumatized, child's counsel would have moved already, you know,
Yeah, that
would
actually
be
kind
making
of
some
erased all
strategy.
doubt in my mind. Screw it, you fight for your client, and let the child's attorney fight for them, and let the judge decide.
So that's another.
You can't
I've
get
been
whacked with
thinking about that the whole time.
ineffective counsel, you can't get penalized,
You cover yourself.
you covered yourself.
Cover
That's
yourself.
important to cover
If the
yourself.
kids have
Never
ineffective
forget that.
counsel, they're institutionalized for the rest of their life, it's not their fault.
That's right.
Might sound inhumane, but it's not your fault.
Not inhumane, because if you look at the adversarial system that we're all seeking to enter, you derive comfort, the human being aspect of it, you derive comfort by saying everybody's supposed to do their job in this form. Everybody is supposed to be a zealous advocate for their client. My job is to advance my client's position under the law and ethic. If this causes harm to someone else because someone else has failed to be a zealous advocate, cold as this sounds, my conscience is clear. And I will suggest to you, you will last maybe 20 minutes as a litigator if you don't have the ability to do that. Because if you start thinking, well, I've got to sort of manage everything. I've got to advance my client's position. I've got to be sure this person doesn't get hurt. I've got to be sure that doesn't get lost. No. The way you litigate is you say, I have faith in the adversarial process. I'm advancing my client's position. The person who represents the party that may suffer is supposed to advocate their position. And Ilya said, it's up to the judge to sort that out. If you start thinking, I've got to contemplate all these different agendas, you're not being a zealous advocate, number one. Number two, you've taken so much responsibility onto your shoulders, you're going to burn out in no time at all. You know, I think both Ilya and I, when we walk out, when we finish a trial, regardless of the outcome, you go home with yourself. Because we have done our jobs. And if there was an unfavorable outcome, that there was collateral damage caused, because someone didn't do their job. And the minute you start trying to do everybody's job, you're doing nobody's job.
That's right.
You're no good as an advocate. The bad things are going to happen anyway. And the bottom line is you're useless.
Yeah, right, absolutely.
Can I have you and Delia discuss the appeals court directive and then what happened after that?
I remember the appeals court, and again, forgive me because I haven't recently read the case, Paula, but the appeals court really came down on the department and really came down on the judge and instructed the trial court to. There's this, if you look at that case law, Jeremiah, if you have it in front of you,
Yep.
there's specific language, and I want to say it's on the second page, of how the appeals court instructed the trial court in how to proceed.
So the court mandated the judge.
The judge shall determine whether
Yeah,
the
go ahead,
department
read
has
it.
sufficient additional current evidence from the period subsequent to the trial to show previous shortcomings or handicaps putting the children at serious risk, so as to warrant a new trial. If so, to proceed forthwith with the trial consistent with this opinion. Otherwise, if a new trial is unwarranted or the proceed unwarranted or the department's goal has changed, a plan for reunification of parents with the children with adequate services by the department shall be devised and implemented by judicial oversight and approval. Yeah, it's a lot
So
of,
there was
shalls and shall nots.
Well, there's a specific instruction, and what it required was a hearing to determine whether another hearing should happen or not. Does that make sense?
Yep.
There should be a hearing, and after the conclusion of that hearing, it will be decided whether another hearing will happen, and if not, then to transition the kids immediately, forthwith. Now, I don't know if you recall this part.
This is the section I recall.
So, the trial court, the case came back to the trial court, and that particular trial judge, of course, again, had this instruction, which I believed she did not follow. Okay? She didn't.
What did she do
Yeah.
instead?
Made a decision.
What was that decision?
The department will present, the kids won't be transitioned home. There will be another trial, essentially. Okay? So there was no hearing to determine whether there was evidence subsequent to the, if you read the language back again, I'll focus better, but there wasn't a hearing to determine whether that existed or not.
That
Oh, yeah.
changed.
Right.
Period subsequent to the trial to show previous shortcomings or handicaps.
Right, she just made the determination that there were, and scheduled the trial again.
So no new evidence, in other words.
Right, and there's another issue too.
So we appealed that she did not file that she did not follow the instruction from the appellate court, and that went to a single justice. And you remember that hearing? You guys got slapped around. No, when I think back at that, because I went to that hearing.
Now,
And then the single justice sent it back,
And said what? What was the directive then when the single justice sent it back?
all I know is that there was an immediate transition ordered.
we also wrestled with the language of the decision. Grievous shortcoming. We hadn't found other cases where we had any burden to show grievous, and there was one other word.
Handicaps.
Grievous and shortcomings and
Well,
handicaps.
Yeah.
Grievous shortcomings has been mentioned in case law to
Yeah.
determine unfitness.
The handicap part, shortcomings and handicaps.
It's or, not in. Yeah.
So.
No, we went back and had the hearing, that's what we did. We went back and we had the hearing, and the judge returned the children home.
So the
That's
inter-
what happened.
That's right.
'Cause
You're
that's not-
jumping way far
But-
ahead.
I'm sorry.
And that wasn't
Yeah.
supposed to happen at that hearing. That first hearing was supposed to determine whether you needed another
Right.
hearing, right?
Right, but it didn't play out that
And
way.
because it didn't, then she went to the single justice, and then the single justice sent it back down.
Again.
And then when it went back down again, then they had the trial. And it was at that trial that the judge changed position, so to speak. And
So the interesting thing that we thought about was grievous shortcomings. Okay, well, what about handicaps? Can we show, what are handicaps? We didn't feel we had a lot of guidance. That was what I argued. That was our
Appellate
position.
court?
It's handicaps.
What does that mean?
Putting the children at risk.
But there was nothing subsequent.
We felt we still had evidence from the judge found.
Right. So then the judge did find that the department had not met its burden and returned the kids. That's not how it played out, but that was the decision. And it didn't play out that way because it just, and that was hard, getting parents to understand that and agree to that. But the children ended up getting adopted, they did. They stayed where they were. They were in fact adopted.
in spite of the fact, if
in
you
spite
guys
of the fact
understand,
that
the
they
parents
won.
now have won.
They won. They won.
So
Those
how-
kids were to be sent home.
So how did they win and the kids still got adopted?
Well, because from my perspective, you know, and you'll do this as a trial attorney, you're constantly two tracks, you're trying to negotiate while you're forward, and I think the parents realize that these children, through no fault of the biological parents, they had lives at that point. And the adoptive parents, the biological parents, while I can't say that they get along, but the biological parents, to their credit, the reality, and essentially said, we're going to agree to allow these boys to be adopted. Not because we lost, not because we were unfit, but because we love them and we think this is the best thing for them. And that was the final outcome, which is yet another example of why litigation is an art, not a science. You have to be, when you become a litigator, you have all of your mental senses engaged all the time, because things can go in an infinite number of directions.
Right.
And you'll see trial attorneys have one way of doing things, they have one outcome that they want. I don't think they're always the most effective, because you have to be nimble and say, well, things are now different. Things are different. Now, let me ask you a question. If the department did not have any new evidence after the appeals court, if we had no new evidence, should we have gone forward anyway, as zealous advocates? My client said to me, I don't really have any new evidence. Should I, as a zealous advocate, say, well, we're fighting?
Have to.
You say yes?
I agree.
You agree? Everybody agree? We're a zealous advocate. The client says, I don't have any new evidence, but I'm a zealous advocate. I'm
Otherwise,
going.
you can't be wasting the court's time. You're trapped in that position.
Just in time. Save yourself from Rule 11 sanctions. What I said earlier about your duty to the client and the court,
You waste your time.
if you don't have new evidence, it doesn't matter what your client has, because then that's a frivolous action. So if my client had said what I just suggested, gee, we don't have anything new, my duty would have been to say, then we're done. I have not been moving forward. I don't care about clients, just as you shouldn't care about your clients. If there's no evidence that you believe is admissible, you're done. And there is a rule that can sanction you if you don't think you're done. That's always very important. That's why at the end, you know, your client can say what he or she wants, but you're the one. You're the officer of the court. That's why we don't let people walking off the street and just practice law. Somebody's head has to be on the chopping block to do it. Mine and Ilya's. That was the outcome of the case. And
It was hard getting them to that point, Chris. That took a lot of work to get them to that.
How many years have elapsed?
That's what I was about
From
to
when
ask.
she first lost custody to that point?
Well, I know you
The
filed.
youngest one was born in 1999, so that'd be what, 12 years?
Well, they took the kids away in 2002.
13 years?
2002.
Trial in August of '07. Appeals court stayed in '09. But this is just the appeals
Right,
court
this
that brought
was
it back down.
A
And
year
then
or
you
two
guys
after
said-
that?
Yeah,
You guys said you went for another round of dancing all the way up to an SJC.
yeah,
And back.
yep.
Born in 99, and then-
Years.
So
like
2002,
12
it was 7 years
months,
just to get this
12.
decision.
Right.
So then it sounds like the kids were with the pre-adopted parents.
Not
2 to
those
3 times
particular
longer.
They weren't always
pre-adopted
with-
parents.
yeah.
They were bounced around a little bit. When they eventually got to the pre-adopted parents that adopted them, they hadn't been there for that many years.
Oh.
I wanna say 2 for one of them.
I don't know.
2 for one of them, and
But if they were bounced around, did they have more time with their pre-adopted parents than they actually had with their biological parents?
well, that's another thing that was brought up. That's you know, pretty sharp of you to ask that. That was something that was brought up, absolutely, is basis are you saying that these kids are bonded to pre-adopted homes more than they would be to their own parents? I would argue they weren't. They were moved quite a bit. I want to say 4 or 5 times before they ended up. They were at one point together, and then the foster parents could not manage it, so then they were separated, and they went to another home. There was a home they went to that was of an entirely different culture. I remember that. So that's, you know, interesting that you brought that up.
But for how long were they with those?
Short periods of time, not for any great length of stay.
But never back with the bio parents.
Right.
So then it would be the children's attorney to bring that up, right?
Bring what up?
to bring that point that you just made, as far as them bouncing around and them not really, the relationship with their parents would be, of course, more.
The children's attorney was in support of the department's
Yeah,
position.
in this case.
Now, would that have been new evidence for the department, that, hey, at this point in time, they have more bonding time with this pre-adoptive parents than they do with the bio parents? Could that have constituted new evidence?
Well, that was,
And our argument was,
Yeah.
the reason, our argument was that Maya parents' failure to get things together sufficiently is why boards are kept.
but you know, that case, and I'm not sure if I'm right about this, Chris.
I think
was
nothing
it-
good ever really starts with that.
Yeah. I think it was our case that brought about this new rule that when a trial begins, it will go consecutive, day to day to day to day until it is concluded.
I think that's right.
Am I right about that?
That was the
Because
timing
this,
was right.
I
I'll
know
tell
the
you,
twist on
the-
this case is the judge was going through some family issues.
Right.
Cancer and bereavement issues and, right?
Yeah,
And
a
so
very
there were
personal, yeah.
trial cancellations and rescheduling.
oh yeah, cancellations, rescheduling, continuances.
And in fairness to the judge, you know, is there a constitutional right to a speedy trial in care and protection? What do you think?
Sometimes it would work out, sometimes it.
Remember that famous quote, the full panoply, right? Not afforded in these cases, because they're not criminal trials.
So if there were a lot of arrests and there had to be arraignments the day that we're scheduled for a trial, that's going to move things.
Right.
There's nothing, it took a long time, but the judge didn't do anything improper as a result. Some of it was the judge, some of it was scheduling, some of it was the court. But the fact is, other cases would intervene. If parents have their children removed at night, do they have any statutory rights the next morning? Emergency removal, what happens?
I thought it was 72 hours.
Right, so some people whose kids got removed, they have a statutory right to a hearing within 72 hours. And the way that's supposed to work, they should come to trial, you know, trial and process. But as Ilya just pointed out, there is an administrative rule within the trial court now that says, once the trial for termination begins, it must be wrapped within 30 days.
Yep,
And they pretty much are.
they are.
They're a lot faster. Well, I shouldn't say they're faster, but they stay within a time.
Absolutely. These foster parents also, both families, were not gonna sit back and just watch this happen either. They were devastated. I mean, they were elated when the first decision came down, but devastated when the second decision came down, and further devastated when the final decision came down. They were devastated, and they weren't gonna just sit back. They alerted the media. They went up to Gail Geringer's office. They made a pretty big stink about it. They did. And so I do think that new rule, that administrative rules, is a result of this. I do. It was interesting though. It was interesting. It's like you said, you just never know how things are gonna go. You never know. But I would suggest in care and protection cases, you wanna go through them quickly. You don't wanna let too much time pass. Time can help you. It can also hurt you.
Usually it hurts the families.
Yeah.
Delay helped this family, to their credit, I mean, they did well, but in most cases, delay hurts you. In most
Yep.
cases,
Yep.
delay benefits them.
They have the burden of proof, so you want them to, have to prove it early on when they don't have volumes of evidence. Like a 72-hour hearing, for example. Unless it's really bad where, if it's not, hey,
No, the department's most
at that
day
point.
one of a 72-hour hearing.
That's right.
Do any of you have any other, not just about this case, but general questions about care protection and termination matters of either Ilya or Chris, the top and trial counsel?
My question is this, it's really a medical question. Is there a causal link between the developmental disabilities of two of these children and the addictions of the parents?
You don't know.
No, that's the right answer.
That's a good question.
All your years of experience in your individual roles, how often or if ever do you guys find yourselves individually thinking, I think I'd rather be DCF or anything, basically switching roles? Are you glad the career you guys chose and don't look back? Or?
Oh, do you mean, would I rather sometimes be a prosecutor
Yeah.
versus defense counsel?
And then vice versa.
No, I like buying that. I like what I do. Do you like what you do?
What I do.
You like what you do.
I like to thank you,
Good
so
at
you.
what
I
you do.
mean, you ultimately won, but.
Well, that's because that was,
What I like to do sometimes on cases, though, if I'm on the other side, this is what I'd be doing right now. And I'd like to do that sometimes. But I mean, if you really enjoy litigation, you know, the side you're on, in terms of the actual courtroom experience, I mean, setting aside lifestyle, I mean, there are advantages and disadvantages to each lifestyle, but in terms of the actual practice of litigation, it doesn't really matter which side you're on. If you really enjoy trial law,
yeah.
every case is different, and it's just a great job.
And you know, as Chris said, after every, case, no matter what happens, you go home for supper, I go home for supper. It's also important to be able to go out and have a drink together too, and to not take these things personal. There's nothing personal about it, and I'll tell you, in my years of doing this kind of work or any kind of work, I see a lot of lawyers that harm the client because of their anger or
Stubbornness.
The client pays for that. The client pays for that when there's a bad relationship. So it's not about the client anymore, it's about me getting you back. And to what end? There's a lot of nastiness in this field, don't you think? A lot of nastiness, and who pays for that?
Clients.
Yeah, they do. Oh, yeah, they do.
It's a failure by the attorney. And you'll see this.
It's a
because
terrible thing.
It's the majority now.
I think so too.
And you'll see it. You'll see people get angry with you.
Ah.
It's so fair.
There's no room for any of that. I have someone that I represent, you do, we respect each other, we do our best, and at the end of the day, we're going to have a beer together.
Yeah, you said you have someone you represent, you are not that person.
That's correct.
So you don't have the right to be emotional and
That's right.
angry. You have to be, yes, you have to be a zealous advocate, but that doesn't mean anger
That's
or
right.
any of these, emotional issues.
That's right.
We saw that last semester when we had the appeals court sat here.
Mhm.
There were two attorneys up here for the divorce. They were screaming at each other in the parking lot. Clients are gone.
Really?
One of
They
the
started in
cops-
the parking lot?
One
Yeah,
of
they
the cops
started
actually
before.
went out and
That's
split them up.
just nonsense.
Just remember, rudeness is the weak person's imitation of strength.
I like that.
You see it all the time. People think if they're nasty, they're zealous.
Right.
And it's just foolish.
It is.
It just,
Diplomatic and
on one
respectful
level,
is
it's
the way to
comical.
be.
I'll give you one brief example of someone who thought they were clever. Years ago, when I had my first job, I was an associate at a firm, and my wife at the time was pregnant with our first baby, so as an expectant father, I completely changed my entire life for the next 9 months. And I wrote letters to everybody saying, month of April, I'm not available these days, and I'm really not available this week. Of course, everybody agreed. One guy filed a motion to be heard on the day that my wife was going to deliver. I called him up and I said, I gotta keep that day open. And he said, well, that's the way it is. So, a colleague of mine had to go in and cover it, and my colleague said, I'm here for Attorney Cook because he's out on paternity leave, and he had actually requested that this day be kept open. So how do you think the judge responded without doing anything about the case? I mean, this twit, without even being a zealous advocate, the judge is already consumed with hatred for him.
Right. That's right.
Because it was such a crappy thing to do.
It's a waste of time.
A waste of time, and he thinks he's being zealous when he does that, but the judge, well, first of all, the judge continued the matter.
Yeah.
And there's nothing to be gained by nastiness.
That's right.
Nothing at all. We understand sometimes you gotta draw a hard line with your clients in the
You
room.
do. You can throw
but
your weight around when you need to.
You can do it in a way that's friendly, yes.
When you gave us the hypo about what would we do, we represent our client or think, or want to represent the child, what we do about putting the child on the stand. That helped me personally realize that I really wouldn't care about the parent. I get that that's our client and you have to do, because I mean, of course, you know, they retained you and you have to represent your client to the best of your ability, but I'm sorry, I wouldn't think about the parent. And maybe that helps me realize that I'd be for the kids more than for the parents, in a sense. So then it further helps me to realize that I would be an attorney for the kids.
Well, you can't just choose that if you're
I
doing,
know.
that's just not how that works.
I would hope to do that in the future.
Oh, but I'm not gonna let you out that easily, because you'll also have a client, you look at that client and think, you know what? You're a 14-year-old kid who wants to stay in foster care because your mother doesn't let you smoke dope in the backyard.
Oh, that's a different story.
But there's an issue there. But you've got to advocate that child's position. You may say, you know, it's good for this little kid to go home because the parents are appropriately strict, and I now understand what's going on. Now you're going to advocate for your client in a way that you think is bad.
Yep.
See, you don't have the ability
Yep.
to bring your personal value system into play. You just don't.
My question has to do with the personal value system. It's just like a personal question for you guys. When you first started out, did you find yourself getting like attached, like, for example, like she said, I wouldn't care about the parents. Did you ever like find that happening to you, or are you thinking along those lines?
I've always represented faceless entities, and we don't care about anybody.
He's right, that's a good answer.
I mean, have you ever found yourself like really like, oh my, like either in tears or just overwhelmed, or either by the case?
Everyone, and I get along with everyone. I don't care who they are, what they are. I get along with everyone, and I think that's more of a strength than it is. You know, I joke around with Paula all the time about it, but my skill, and I joke around with you about it, but my skill more in this business is people skills.
Right.
You know, and I found that, no, to answer your question, I don't get attached. I don't get attached in where I let emotions start clouding what I'm doing. Not that I'm not an emotional person and a warm person, I am, but I don't get attached like that. I have a job to do, and I just do my very best to work for that particular person, whether it's a kid, whether it's a mother or a father, it doesn't matter. I'm going to give it my all, I'm going to give it my best, and I'm going to get along with everybody in the picture. Because in my mind, this is about a family.
Right.
It's not about one person, it's about a family. So I don't know if that answers your question.
No, it does.
You have to remember something too. Clients don't give you the full story. Okay, there are two reasons they don't. Sometimes they lie, and it's your job to make sure that those lies don't get into court.
Right.
But everybody, whether consciously or subconsciously, spins the facts. So you may suddenly, if you're allowing your emotions and your value system to kick in, you've ceased to analyze coldly, and you're taking this spin and you're internalizing it. And look, if you would have asked me personally, if I were your client, I think I'm an honest person, you asked me to give you a set of facts that are deeply personal to me, I would subconsciously spin them, of course I would. Nobody, that's why we don't represent ourselves, right? But the minute you start becoming involved with the client's story, you see, you've crossed the line, because your job is not to have the emotional connection. They need your client, put differently, your client needs the unemotional advocate.
That's right.
So if you find yourself involved and getting weepy, guess what? You're no longer being the advocate your client needs. It's like a physician saying, you know, this is really going to hurt, so I'm just not going to do it.
Right.
Because I know you're terrified of needles.
Right.
I know you're scared of needles. It breaks my heart to put you through this. I'm not going to give you the shot, and I hope you won't get sick, because I care deeply about you and your pain and your fear of needles, and that's kind of what it is.
Right.
Yeah.
And then the patient dies tomorrow.
And then, yeah.
Hopefully you won't, because you will not, but I don't have the ability to do what's going to hurt. And unfortunately, what Ilya has to deal with that I don't, I mean, I have my own set of client problems. But, you know, Ilya will often have folks who might have a mental illness or a substance abuse problem. And heavens knows what to say.
Yeah.
You know, what crazy theory of the moment. You know, and I've got people sometimes who should know better because they're trained, and I have to face the crazy theory of the moment.
It's good work, though. It's good work.
Speaking of which, I must go.
Okay, and we'll let everybody go then. We'll do the rest of the case until Thursday.
Thank you.
Thank you.
Thank you.
see you guys later.
Thanks, Chris.
Chris, take it easy.
Good seeing you.